any government organization and scholar publications. In this, we use and identifies the issues and challenges of the new economic reforms in India in 1990. That the new age of economic reforms have faced the several issues and challenges. Some are the inequality. Despite the economic reforms, India still struggle with the high level of the inequality. The main challenges is that we remove their inequalities to adopting the new economic reform. This is because the benefit of economic reform has not been disturbed equally among all the section of the society. The gap between the rich and poor continue to widen, and this led to the social unrest in some part of the country. Economic reforms increase the market capacity and increase the economy, but inequality is always there at the time. Infrastructure, improve the develop the infrastructure has a major challenge for the Indian economy. There are still many parts of the country has a lack basic infrastructures like buildings. Yes, and second is corruption. We already know that India is a political, well-established country. There is always corruption in the bureaucracy and the other government departments and private departments. Third is educational skills. Educational skills is very important for. We have to improve our educational standard and the skill labor, produce the skill labors. Now that is the agriculture sector. Agriculture, we have to many other things to increase in the agriculture sector. Basic facilities provided to the poor and the farmers. And second is regulatory involvement. Third is infrastructure financing. The challenges of mobilizing the adequate infrastructure financing is one of the major challenges faced by the Indian economic reforms. The country needs stabilized funds for the infrastructure development, but mobilizing such as fund traditional methods became basic difference. There are, let's finally go to the conclusion. In the study that the new age economic reforms has a significant impact on the country economic growth, but there is still significant challenges to need to address, make reforms more inclusive and beneficial for the society. Reforms may be aimed to liberalize the economy, promoting private enterprises and attracting foreign investment. Overall, the reforms has been successful in driving the economic growth, improving the competitiveness and increasing foreign investment. The reform lead to increase the income inequality, benefit construction urban areas among the middle class and the upper middle class to improve the living of standard of the middle class families. Lastly, we concluding remark. India's new age economic reforms has successfully to drive the economic growth of the country. We developed our economic condition, but they need to more inclusive and address to issues and challenges that facing the economy. This lead to future reforms as income inequality, agriculture distress, corruption, infrastructure deficit, and ensure the sustainable and inclusive economic growth in the country. We have to improve and launch a new economic reforms for the country to reduce this type of inequalities, agriculture, insufficiency, corruption, to reduce them and country maybe go to the development path. Thank you so much. Any queries related to the presentation or topic? Yes, ma'am. More than 20 years. Yes.
वापस आके बोलना है ना बन गई मैडम या तो ताजी बनवाना
इकोनॉमिक रिफॉर्म्स हम लाने के पीछे क्या रीजन थे? गल्फ वॉर थे, हमारी करेंसी इकोनॉमी जो थी वो डेप्थ में थी, लोन हमारे ऊपर ज्यादा हो चुका था, वर्ल्ड बैंक और IMF ने लोन देने से भी मना कर दिया था। तो हमें अपने कंट्री के मार्केट पूरे प्राइवेट प्लेयर्स के लिए और ग्लोबल मार्केट के लिए खोलने पड़े, क्योंकि हमारे पास इन्वेस्टमेंट यानी इन्फ्लोज नहीं थे उसको लाने के लिए हमने किया। आफ्टर दैट डेवलपमेंट हुआ, बहुत सारे प्राइवेट प्लेयर्स हमारे यहाँ आए, ग्लोबलाइज फॉरेन डायरेक्ट इन्वेस्टमेंट हुई। उसके अलावा भी न्यू रिफॉर्म्स की वजह से हमारे पास कुछ चैलेंजेस हैं जो मैंने बताया, एग्रीकल्चर से, इनइक्वालिटी से, करप्शन से। हमारे पास अभी भी हमारी एजुकेशन मतलब लिटरेसी रेट कम है, एजुकेशनल टेक्निकल एजुकेशन हमारी बहुत पुअर है, मैनेजरियल एजुकेशन हमारी पुअर है। तो इनको भी इम्प्रूव करना पड़ेगा इनको इम्प्रूव करने के लिए हमें किसी न किसी रिफॉर्म्स की जरूरत है. तो आफ्टर 23 years of the new economic reforms, we need a new economic reforms for the further development of the country. That you need.
नहीं, जाओ जाओ.
Thank you so much, sir, for such a wonderful presentation. Moving ahead, I would like to invite Mr. Aditya Narayan Mishra, sir, for his presentation. So, please, I request you to come on stage.
सभी प्रेजेंटेशन कौन सी है ये ना. सब चल रहा है ना प्रॉपर. स्विच कर सकते हैं अपन. स्विच कर सकते हैं जगह. क्या हम भाई जाके बैठ जाओ. मैं बैठ जाता हूँ. अरे बाकी मैडम भी बैठेंगे ना यहाँ पे भी. वो वहाँ बैठेंगे ना. हाँ हाँ हवाई. अरे आप जाओ नीचे. मैं देख लूँगा. आप बेफिक्र रहो.
Good afternoon to all the respected
Good afternoon to all the respected dignitaries and all my colleagues and friends. My topic is role of Indian judiciary in protecting environment.
So, firstly,
environment. Environment is the wellspring of life on earth, like water, air, soil, etc., and determines the presence and development and improvement of humanity and all its activities. And the concept of ecological protection and preservation is not a new concept. It has been interesting in many ancient civilizations, and the Indian text highlights that it is the dharma of each individual in the society to protect nature. And in the Atharvaveda, the ancient Hindus, the scepters stated, "What of the ill I dig out, let that quickly grow over."
And in the recent years,
there has been a sustained focus on the role played by the higher judiciary in devising and monitoring the implementation of measures of pollution and control conservation of forests and wildlife protections. Many of the judicial interventions have been triggered by the persistent incoherence in policy making as well as the lack of capacity building among the executive agencies. Devices such as the public interest litigation have been prominently relied upon to tackle environmental problems, and this approach has its support as well as critics. Now it's the meaning of the environment. The environment relates to the surrounding. It includes virtually everything. It can be defined as anything which may be treated as covering the physical surrounding that are common to all of us. And according to Section 2A of the Indian to the Environment Protection Act 1986, environment includes water, air, land, and the interrelationship which exists among and between water, air, and land, and human beings and other living creatures, plants, microorganisms, and property. So we can say that environment means the surrounding in which we live and is essential for our life.
Now, and now the protection for the environment. Environment law
Is a new domain in the jurisprudence at the global level. At the national level, even 3 years ahead of the Stockholm Summit that was held in 1972, India, India even made
ahead of Stockholm Summit, India made a note that in fourth 5-year plan,
the, 3 years ahead of Stockholm Summit, India made a note that
environmental factors into the planning.
in fourth 5-year plan, that is from 1974, and
the unity of nature and
integrating environmental factors into the planning.
the basis of a comprehensive
The fourth plan document for harmonious development recognized the unity of nature and man. Some planning is possible only on the basis of a comprehensive appraisal of the environmental issue. There are certain instances where proper and timely advice regarding environment could have helped in designing
the environmental aspect into the planning
projects and in changing adverse effects on the environment, which leads to loss of resources.
Now, judicial remedies for
It is
environmental
necessary,
pollution.
therefore, to
There are
introduce
two
the
types
environmental
of judicial
aspects into
remedies:
the planning and
ordinary
development.
liabilities and judicial and statutory liabilities. In the tortious liability, such as trespass,
Now,
nuisance, strict
judicial
liability,
remedies for environmental pollution.
and in
There are two
statutory liability,
types of judicial
interpretation
remedies, that is
under
tortious liability
Section 19 of the
and
Environment
judicial
Protection Act,
and
Section
statutory liability.
133 of the
In the
CRPC,
tortious liability,
Procedure Code,
such as trespass,
and
nuisance, strict
260 of
liability,
the Indian
negligence,
Penal Code.
etc.
Apart
And
from
in statutory
under
remedies,
Article
incorporate
252
citizens suit
in the
under
Supreme Court and under Article 226
Section 19 of
of
the
the High
Environment
Court.
Protection Act, Section 133 of the CRPC,
Now,
that
there
is
are
Criminal
some
Procedure
doctrines
Code
which are involved by the
1973,
Indian judiciary
and
that are absolute liability
Section
doctrines
268
and the doctrine of principle
of
of public pay,
the
principle of
Indian Penal
cautionary
Code.
actions, doctrine of public trust, and the sustainable development doctrine.
Apart from this,
The first doctrine is doctrine of
under
absolute
Article
liability.
32
In the Bhopal gas case, that is Union Carbide Corporation versus Union of India,
in the Supreme Court and under Article
where an
226
enterprise
in the High Court.
occupied with an inherently dangerous or a hazardous activities and harms vision to anybody by virtue of a visit in the
Now,
operation of
there are
gas,
some doctrines which
that
are
is unseen movement of
involved by the Indian
for
judiciary,
instance, in gateway of poisonous
that
gas,
are absolute liability doctrine
strictly and
and the doctrine of
completely applied
principle of polluter
every
pay,
one of the
principle of precautionary
not
action,
influenced by
doctrine of
the
public trust,
accident
and
and
the sustainable development doctrine.
any exemptions. According to Supreme Court, the Supreme Court created
The
another
first doctrine is
of
doctrine of absolute liability.
of any
In the
accident.
Bhopal gas case, that is Union Carbide Corporation versus Union of India,
And the
in
famous
this
code
case,
of
court
trade,
held that
if
when
any
an enterprise is
intentionally
occupied
influenced
with an inherently
that is
dangerous
not
or
only
a hazardous activity
but purely
and
by
harms
trust
result to anybody
systems which
by
contains the
virtue of a
water.
mistake in the operation of
This
such dangerous
document
or
principle is very clear.
naturally
That
unseen
is,
movement coming about.
if you make
For
a
instance,
price, it
in gateway of poisonous gas, the enterprise is
so in
strictly and
the
completely obliged to
welfare
repay every one of the individuals
the
who are
Supreme Court has
influenced
created
by
a
the
particular
accident, and
principle
such risk
which
is
is
not
feature
subject to
of the
any
sustainable
exemptions.
development.
According to Supreme Court, the Supreme Court created another trend of absolute liability without any exemption.
And again, in the case of Valo,
And the second principle is polluter pay principle.
forum
And the famous quote of Plato said that if anyone intentionally spoils the water of another, let him not only pay damages but
environmental
purify the stream or cisterns which contains the water. This polluter pay principle is based on the Plato's quote: if you make a mess, it's your duty to clean it up. So, in the Valor Citizens Welfare Forum versus Union of India, the Supreme Court has declared that the polluter pay principle is an essential feature of the sustainable development. Next doctrine is precautionary principles. And again, in the case of Valor Citizens Forum case, Valor Forum versus Union of India, the Supreme Court held that the development, the following three concepts for the precautionary principles, and that are environmental measures must anticipate, prevent, and attack the cause of environmental degradation. Lack of scientific certainty should not be used as a reason for postponing measures, and onus of proof is on the actor to show that his action is winning.
Sir, one
The
minute.
next doctrine is public trust doctrine. The,
and the doctrine of sustainable development, the World
the
Commission
public trust doctrine primarily rests on the principle that certain resources like air, water, sea, and the forest have such a great importance to people as a whole that it would
and
be
in the case of rural litigation and entitlement case, that is
wholly unjustified to make them a subject of private ownership. And
for the
in the
first
case of MC Mehta versus Union versus Kamalnath and
development. And
others, the public trust
it is
doctrine,
to be remembered
as
that
discussed by the court in this judgment, is a part of the
and of not
law of the land.
to be exhausted in one generation.
And the last doctrine
Now the constitutional aspect of environment by the 42nd Amendment 1976, the directive principles of state policy under Article 48A. The directive principles of state policy and Article 51 AG under fundamental duties. It was inserted that it is the duty of the state
highlight the concept of sustainable development. As per report, sustainable development signifies development
and in the case
that
of West
meets
Bengal
the
body of the
needs of
state
the
of West
present
Bengal,
without
Supreme Court
compromising the ability of the
wherever
future
problem
generation
of
to meet
technology is
this
brought
objective.
before the court,
In the case of rural litigation and in the entitlement case, that is RLEK versus state of UP, the court said that the court for the first time deals with the issue relating to the environment and development. And in that, it is always to be remembered that there are no permanent asset of mankind and of not intended to be
for environmental
exhausted in
protection.
one generation.
In this way, the judiciary tries to fill in the gaps where
The
there is
constitutional aspect of
lackness
environment,
of legislation.
by the 42nd Amendment,
Innovations and development in India
1976,
by the
the,
judiciary to
the
preserve open
directive
the
principles of
development
state
efforts in
policy
the country.
under
And
that
in
is
India,
directive principles of state policy and under fundamental duties.
about the
It was
nature of environmental rights, considering
the
that the loss of natural resources
fundamental duty of every citizen to protect the environment. And in the case of Satchidanand Pandey versus State of West Bengal, the Supreme Court observed whenever a problem of ecology is brought before the court, it is found to bear in mind Article 48 and Article 51 AG. Now to the conclusion part, thus after the analysis of cases, we find that
फॉलो करना चाहिए और वो लगातार environment protection के लिए काम
the Supreme Court is at the present time stretching the different legal provisions for environmental protection. In this way, the judiciary tries to fill in the gaps where there is a latent of legislation. These new innovations and development in India by the judicial activism open the numerous efforts to help the country. And in India, the courts are extremely cognizant and cautious about the special nature of environmental rights.
Under Article 21, right to
Considering
health
that the loss of natural resources can't
is
be
a part of right to life and personal liberty. So it is a duty.
Thank you.
In my opinion, that right to life is more important than Article 19. यदि जीवन है तो आगे जीवन होगी, यदि नहीं होगा तो आगे जीवन नहीं होगा। तो जीवन को पहले बचाया जाए। Yes.
केवल एक मिनट बाकी चेंज कर रहा सर पीछे तो लाना पड़ेगा ऑडियो में तो सर कैसे रहेगा अगर उनको सुनाना होगा सर देना पड़ेगा ना ऑडियो तो ऑडियो ऑन कर
विश्वास पवार
ऋषिराज सर
ready for the presentation? Are you ready for the presentation? Sir, unmute your mic and camera and sir, start with the presentation. We have to 5 to 6 minutes to complete your presentation, highlighting the introduction part, research methodology, and findings and conclusions. Sir, because the lack of time, done fast, sir. सर आप स्टार्ट कर सकते हैं Yes. Yes, sir. Yes, sir. Yes, audible.
माइक ऑफ कर दीजिए सर
Try to conclude my research paper findings and projects. So, first of all, my topic of my research is the critical study of forensic science evidence in criminal investigation. हम क्राइम की बात करते हैं तो सबसे ज़्यादा इम्पोर्टेंट फैक्टर जो हमारे सामने आता है वो ये है
से इनके बारे में डिस्कस किया है क्या डायलेमास फेस करने पड़ते हैं फॉरेंसिक साइंटिस्ट को ड्यूरिंग क्रिमिनल इन्वेस्टिगेशन एंड लास्टली जो प्रोसीजर फॉरेंसिक साइंटिस्ट द्वारा अपनाई जाती हैं उनकी एफिशिएंसी को चेक करने के रिस्पेक्ट में यहाँ पे किया गया है। फर्स्ट हिस्टोरिकल बैकग्राउंड की अगर हम बात करें तो फॉरेंसिक साइंस जो है वो वर्ड डिराइव हुआ है फॉरेंसिक्स लैटिन वर्ड फॉरेंसिक्स से डिराइव हुआ है जिसका मतलब होता है डिस्कशन और पब्लिक आर्गुमेंट। फॉरेंसिक साइंस में जब भी हम बात करते हैं तब हमारा मेजर फोकस होता है कि हम फिजिकल और बायोलॉजिकल एविडेंसेस को कलेक्ट करें। फिजिकल और बायोलॉजिकल एविडेंसेस के साथ में
क्या क्या चीजें आती है, लाइक ये कौन कौन सी एरियाज को डील करता है? सॉरी, हाँ
सर अगर
so you are not audible actually. Sorry sir, I am not able to hear you.
आपकी PPT शेयर कर दीजिए.
Sorry sir,
सर अपनी PPT शेयर कर दीजिए स्क्रीन पर.
okay sure sir.
किसको नेम करना?
Is it visible now?
ये नेम नहीं हो सकता. Zoom थोड़ी ना है.
Sir you are audible. Sir
Okay, my screen is not visible.
No sir, your screen is not visible.
Sir, can I share his PPT?
not visible.
Sir, can I share his PPT?
Yes, you can share the PPT.
Okay, Rishira sir, I am sharing the PPT.
Thank you so much, Asa ma'am. Okay ma'am. Okay.
Rishad sir, you can share your PPT. सर अपने वीडियो को सर अनलॉक करिए सर, अनम्यूट करिए वीडियो को सर.
ओके,
आपका वीडियो सर आपने लॉक कर रखा है अपना कैमरा, उसको ऑन कर लीजिए सर. हाँ सर वीडियो वाला. हाँ सर अब आप दिख रहे हैं सर.
अब मैं शेयर कर सकता हूं.
हाँ सर अब अपनी PPT आपकी शेयर हो जाएगी सर. आप शेयर स्क्रीन करेंगे उसमें तो शेयर हो जाएगी सर.
इट इज नॉट शेयरिंग एक्चुअली. ये शेयर का ऑप्शन इसमें नहीं आ रहा है सर. इज इट विजिबल राइट नाउ?
सर यू आर विजिबल.
माय PPT इज नॉट विजिबल. You are not audible actually. I'm sorry.
Well, complete.
Rishi Raj sir, I would request you can continue with your conclusion.
Okay. So next. What are the issues affecting forensic evidences and criminal investigation? So, the first issue is the contamination of evidence in crime scene. So, always forensic samples की जब हम बात करते हैं, जब हम उनको collect करते हैं, तो सब quality always matters. So, quality always determine करती है कि उसकी corroborative values क्या होगी. इसके अलावा जब हम कंटामिनेशन ऑफ एविडेंसेस होते हैं, हमारे यहाँ पर ज्यादातर पुलिस ऑफिसर्स जो होते हैं वो इस तरीके से ज्यादा प्रोफेशनल्स नहीं होते हैं और प्रॉपर सीक्वेंसिंग की हमेशा जो है वो प्रॉब्लम आती है. प्रॉपर सीक्वेंसिंग की अगर हम बात करें कि फ्रॉम द रिसीविंग ऑफ द इंफॉर्मेशन क्राइम सीन पे पहुंचने से लेकर के सारे एविडेंसेस कलेक्ट करने तक की जो सारी बातें होती है वो सीक्वेंसिंग की बात करते हैं. यहाँ पर हमारे साथ में इशू होता है. दूसरी अगर हम बात करें कि क्राइम सीन्स पर किस तरीके से चीजों को हैंडल करना है, अगर कोई डिसऑर्डरली क्राइम सीन है तो उसको क्या चीज करना है उसके बारे में नॉलेज और ट्रेनिंग जो है उनको पास नहीं होती. देयर इज ऑलवेज चांसेस ऑफ पर्पसफुल कंटामिनेशन ऑफ क्राइम सीन्स बिकॉज ऑफ सो दैट हम जो है ऑफेंडर को बचा सकते हैं. तो ये सारे इश्यूज जो होते हैं वो आते हैं कंटामिनेशन. नेक्स्ट इशू की बात करें तो सेल्फ रेगुलेशन. जितने भी फॉरेंसिक साइंस एविडेंस है हमारे पास में सबसे ज्यादा प्रॉब्लमेटिक बात जो आती है वो ये है कि जितने भी फॉरेंसिक साइंटिस्ट होते हैं वो अपने आप को ये समझते हैं कि दे आर द रिप्रेजेंटेटिव ऑफ द स्टेट.
बट इट इज नॉट ट्रू। फॉरेंसिक साइंस एविडेंस में सबसे इंपॉर्टेंट चीज ये है कि हमें जो प्रेजेंट करना है वो इम्पार्शियल होना चाहिए। तो सेल्फ रेगुलेशन में हमारे पास ये सबसे ज्यादा दिक्कत आती है कि इनके पास में कोई सेल्फ रेगुलेशन गाइड नहीं है। ये होम डिपार्टमेंट के थ्रू या पुलिस ऑर्गेनाइजेशन के थ्रू डील करते हैं। तो ये और ये अल्टीमेटली कहीं ना कहीं लेकर के जाता है कॉग्निटिव बायसनेस की तरफ में, और उस वजह से कंक्लूजन ड्रॉ किया जाता है सब्जेक्टिव जजमेंट बेस पर। नेक्स्ट इश्यूज की अगर हम बात करें तो ये है बायसनेस, जो मैं ऑलरेडी डिस्कस कर चुका हूँ। बायसनेस में मैं कुछ पॉइंट्स और भी डिस्कस करना चाहता हूँ कि एक तो हमारे पास में कि इंक्लिनेशन टुवर्ड्स वन पार्टी, कि हम ऐसा मान के चलते हैं कि स्टेट्स जो है फॉरेंसिक साइंटिस्ट ऐसा मान के चलते हैं कि स्टेट की तरफ हम लोग हैं। दूसरा जो इशू इसके साथ में आता है वो आता है साइजेबल बैकलॉग। फॉरेंसिक साइंस लेबोरेटरीज में इतना ज्यादा बैकलॉग है कि डायरेक्टर्स और इनके पास में ये एक ऑब्जेक्टिव होता है कि वो किस तरीके से जल्द से जल्द इस बैकलॉग को खत्म करें। दूसरी बात, ग्रेटर सपोर्ट फ्रॉम क्रिमिनल प्रोसिक्यूशन। जब भी हम फॉरेंसिक साइंटिस्ट की बात करते हैं तो सबसे पहला अप्रोच करने वाला जो है साइड ही वो होता है प्रोसिक्यूशन। तो प्रोसिक्यूशन ही सबसे पहले फॉरेंसिक साइंस के पास में जाता है और उनके पास में उनसे हेल्प लेता है। तो वो जनरली उनके पास में क्या होता है कि उन्हीं का मेजर सपोर्ट होता है। तो यहाँ पर ये बायसनेस का एक ऑप्शन आ जाता है। अगर इसमें बात करें हम तो मिस आइडेंटिफिकेशन ऑफ एविडेंसेस, यानी कि कई बार एविडेंसेस को मिस आइडेंटिफाई कर लिया जाता है और वो रिजल्ट गलत तरीके से शो करता है, और ये भी एक रीजन रहता है इस चीज में। नेक्स्ट इशू इज इंडिविजुअलाइजेशन। आप सभी लोग जानते हैं कि हर एक पर्सन के अपने एक ट्रेड्स होते हैं। इंडिविजुअलाइजेशन की जब हम बात करते हैं, इंडिविजुअलाइजेशन मींस डिस्टिंग्विशेस अ पर्सन फ्रॉम द रेस्ट ऑफ द वर्ल्ड। लाइक फॉर एग्जांपल, कोई पर्सन अगर लेफ्ट हैंडर या किसी पर्सन के एक स्पेसिफिक फिंगरप्रिंट से ये उसकी स्पेसिफिक ट्रेट्स बताता है, यूनिक ट्रेट्स बताता है। लेकिन मान लीजिए एक ऐसी चीज है, ऐसे एक इन्वेस्टिगेशन में पता चलता है, लाइक फॉर एग्जांपल हमें पता चलता है कि देयर आर सर्टेन एविडेंसेस जो शो करते हैं कि जो क्राइम करने वाला व्यक्ति है वो किसी तरीके से कोई लाइक फिजिकली हैंडीकैप्ड है और वो हमारे पास में आ जाता है। और हमारे पास में जो अक्यूज है, जो सस्पेक्ट है, वो मान लीजिए वो भी एक फिजिकली हैंडीकैप्ड है। तो हमने क्या मान लिया कि हाँ यही व्यक्ति ने, क्योंकि ये अक्यूज है तो यही व्यक्ति जो होगा वो जो है उसने क्राइम किया होगा। लेकिन हम ये चीज को इग्नोर कर देते हैं कि जब हम इंडिविजुअलाइजेशन की बात कर देते हैं कि हम इसको तो मान रहे हैं कि ये व्यक्ति और उस व्यक्ति की सिमिलैरिटीज हैं, लेकिन हम इसको डिस्टिंग्विश नहीं कर पा रहे हैं कि सारे इस पूरे वर्ल्ड में कितने सारे ऐसे लोग हैं जो सेम ट्रेट्स रखते हैं। तो ये भी एक डिफिकल्टी होती है कि अगर हम जहाँ पर मिलता है यूनिकनेस को नहीं पकड़ते हैं, हम जनरलिटी को पकड़ते हैं, ये चीजें रीजन होती है। दूसरा, प्रेजेंटेड इन पार्ट्स। लाइक जब भी हम ऐसे एविडेंसेस को प्रेजेंट करते हैं तो इनको पार्ट्स में प्रेजेंट किया जाता है, प्रॉपर सीक्वेंसिंग नहीं होती, और ये भी एक इशू होता है जो फॉरेंसिक साइंस को लेस प्रोबेटिव बनाता है। मोर इश्यूज की बात करें, एविडेंस इज नॉट कम्युनिकेटेड कोर्टरूम इन फॉर्म ऑफ प्रोबेबिलिटी कैलकुलेशंस। प्रोबेबिलिटी कैलकुलेशंस क्या होते हैं? लाइक फॉर एग्जांपल, अगर मैं ये बताऊं कि ऐसी चीजें की होने की संभावनाएं ये हैं, या इस चीज की होने की इतनी ज्यादा संभावनाएं हैं, या ऐसा न होने की भी इतनी संभावनाएं हैं, वो चीज हम कभी नहीं करते। लाइक इस केस में सिर्फ ये होता है कि आप बताते हो कि हाँ ये इस चीज से मैच हो रहा है और ये चीजें हो रही है, उसमें प्रोबेबिलिटी कैलकुलेशंस के बारे में डिटेल एक्सप्लेनेशन नहीं होता है। ये भी एक तरीके से इंडिविजुअलाइजेशन का एक पॉइंट होता है। नेक्स्ट की अगर हम बात करें तो रिलायबिलिटी की, फॉरेंसिक साइंस के ऊपर हम बहुत ज्यादा रिलाई क्यों नहीं कर सकते? रिलायबिलिटी तीन चीजों से के कारण है। फर्स्ट, एब्सेंस ऑफ रिसर्च, सेकंड, scarcity of peer-reviewed articles, and third is validation of studies. अब जब हम बात करते हैं कि ये सारा, अब रिलायबिलिटी की जब हम बात करते हैं, लाइक फिंगरप्रिंटिंग इज द मोस्ट रिलायबल सोर्स, लेकिन अगर आप बात करेंगे इसकी हिस्ट्री की तो इट हैज अ वेरी लेंथी हिस्ट्री, तो ये भी एक रीजन है। दूसरा, लैक ऑफ फंडिंग फॉर द फॉरेंसिक साइंस लैब्स, ब्राइबरी, पार्टीशनशिप, क्वालिटी ऑफ फॉरेंसिक साइंस, क्वालिटी कंट्रोल, कॉम्पिटेंस ऑफ द पीपल एम्प्लॉयड, ये भी रिलायबिलिटी को क्वेश्चन करते हैं। कॉम्पिटेंस ऑफ द पीपल की बात करें तो जनरली हम लोगों ने देखा है कि जो फॉरेंसिक साइंस, जो फिंगरप्रिंट एक्सपर्ट्स होते हैं, उनको हम हैंड राइटिंग एक्सपर्ट्स के तौर पे यूज करने लग जाते हैं। अगेन इट इज क्वेश्चन ऑन रिलायबिलिटी ऑफ द फॉरेंसिक साइंस साइंटिस्ट। नेक्स्ट अगर हम बात करें कोर्ट रूम टेस्टिमनी, तो जब भी कोर्ट रूम टेस्टिमनी में जाते हैं तो तीन फैक्टर हमारे लिए बहुत ज्यादा इंपॉर्टेंट होते हैं, दैट इज प्रेजेंटिंग द रिजल्ट, साइंटिफिक प्रोसेस क्या यूज की हो, तो तीसरा कंक्लूजन क्या, इन तीनों के साथ में और कब हम कोर्ट रूम, इन तीनों चीजों का होना बहुत ज्यादा जरूरी है। इंडियन जुडिशियल सिस्टम जो होता है वो इंडियन एविडेंस एक्ट सेक्शन 45, 46 में ये डील किया जाता है कि एक्सपर्ट एविडेंस जो है वो एडमिसिबल होती है। In a case मुरलीलाल वर्सेस स्टेट ऑफ मध्य प्रदेश, इनसफिशिएंसी ऑफ रिजल्ट्स जो था उसके बारे में डिस्कस किया गया था और उसमें बताया गया था कि इनसफिशिएंसी अगर होती है तो इनको किसी भी तरीके से फॉरेंसिक साइंस को सपोर्ट नहीं किया जा सकता किसी के कन्विक्शन और एक्विटल के रूप में।
ऋषिराज सर,
जी सर।
Sir, session is asking to conclude your PPT, sir.
Yeah, sure. So these are some of the issues. In last, there are certain supports for the science and criminal investigation, forensic science and criminal investigation, because it helps in fill the gap of the criminal investigation. So it is very needed this time. So in concluding, it is impossible right now कि हम बिना साइंटिफिक मेथड्स को यूज किए किस तरीके से प्रोसिक्यूशन या ऑफेंडर्स को पहुंचा सकते, क्योंकि हम 21st सेंचुरी में रह रहे हैं और जो क्रिमिनल्स हैं उनके पास में बहुत सारे टेक्नोलॉजिकल बेनिफिट्स भी हैं और बहुत सारी चीजें हैं, तो उसी के साथ में बहुत सारी इनके ये जो इश्यूज हैं इनको सही करने की जरूरत है। इसी मुहिम में रिसेंट टाइम में मिनिस्ट्री ऑफ होम अफेयर्स ने कुछ फॉरेंसिक साइंस प्रोसीजर्स को भी किया है और कुछ बिल्स भी ऐसे आए हैं जो इस बारे में बात करते हैं। होम मिनिस्ट्री ने इस बार ये सजेस्ट किया है, इनिशिएटिव लिया है कि कोई भी अगर ऐसा अपराध 6 साल से ऊपर पनिशेबल है उसके लिए जो है फॉरेंसिक प्रोसीजर्स को जो है यूज करना कंपल्सरी। दैट्स इट फ्रॉम माय साइड। That is from my side. Thank you so much. Any questions?
सर ऑन करिए उसका माइक को।
Hello. Yes. Sir. Good afternoon, sir.
Good afternoon, sir. You are not clearly audible, sir. Hence.
ऋषिराज जी आप सुन पा रहे हैं मेरी आवाज को?
जी सर, मैं थोड़ा समझने की कोशिश कर पा रहा हूँ। जी सर।
Sir, it was a nice presentation from your side. I have a few questions, but considering the time factor, I'll be asking one question that when we talk about forensic examinations, what we require is the accuracy. And there are various allegations about the accuracy.
Sir, I am not getting you. Actually, the voice is echoing. Can someone, Namandeep sir, may ask the same question?
Hello, sir. Can you hear me now?
Yes, sir. Yes.
Is it better now?
Yeah.
Wait. Hello.
जी sir.
Sir, can you hear me now?
Yeah. Yes, sir.
Okay. So, Rishira sir, I was asking that when it's come to forensic science and criminology, and when it comes to the forensic examinations, what is the most important requirement of a forensic examination? Because it is considered as an examination from the third party, it requires accuracy. And there are always, like as you have mentioned in your slide also, that there is a point of biasness which comes from the side of the examination, the person who is examining.
Yes.
And there are few cases involved in the Supreme Court where it has been stated earlier also that we cannot 100% rely on forensic evidences. So what are your views on it? How to overcome the point of accuracy? And another question, there is a lot of cost involved when it comes to
Yes.
forensic examinations, to how to overcome that issue also. Are there
Yes,
ways
yes.
where we can bring down the cost so that
Okay.
more number of cases can be sent to forensic labs?
So coming to your first question about the accuracy. So there is always a need of special code of conduct. अगर हम एक स्पेशल कोड ऑफ कंडक्ट बना देते हैं तो ऑटोमेटिकली इस सारी चीजों को डील कर देगा एक्यूरेसी से रिलेटेड. सिंस हम हमेशा ये बोलते हैं कि लॉ इज अ डायनामिक कॉन्सेप्ट, सो साइंस इज ऑल्सो डायनामिक, इट्स कीप्स ऑन चेंजिंग. सो जब भी हम चेंज की बात करते हैं तो एक्यूरेसी को हम ज्यादा से ज्यादा R&Ds और इनके थ्रू ही कर सकते हैं. लेकिन सबसे पार्ट दोनों ही क्वेश्चंस अगर आप समझे तो ये अलग क्वेश्चंस नहीं है, दोनों एक ही क्वेश्चंस है. क्यों? जब हम कॉस्ट की बात करते हैं तो यही एक चीज है जो, अगर हम साइंटिफिक एक्सपर्ट्स की बात करें या फॉरेंसिक साइंस की बात करते हैं तो ये वो एरिया है साइंस का जिसको नेग्लेक्ट किया जा रहा है बहुत ज्यादा समय से. इसके ऊपर R&Ds बहुत ज्यादा कम है, पीयर रिव्यूड आर्टिकल्स बहुत ज्यादा कम है. इसके अलावा हम इसके बारे में बात करें तो इसकी प्रोसेस ऑफ वैलिडेशन बहुत ज्यादा कम है. रिसेंट समय में बहुत सारी चीजों में ये बात सामने आई है कि जब हम जो फिंगरप्रिंट्स की बात करते हैं, अभी रिसेंट में नासा यूएस में प्रूफ हुआ है, एक स्टडी में प्रूफ हुआ है कि 2 पीपल में हैव अ सिमिलर फिंगरप्रिंट्स. सो ये सारी चीजें जो हैं वो हैं. तो बेसिकली अगर हम बात करते हैं कॉस्ट की, तो ज्यादा से ज्यादा अगर हम गवर्नमेंट इसको सपोर्ट करेगी तो हो सकता है कि इस चीज में हो ये कॉस्ट को हम कम कर सकते हैं अगर हम ज्यादा उस तरीके से किया जा सकता है. दूसरा, हम एक्यूरेसी की बात करें तो मोरल कोड ऑफ कंडक्ट, स्टैंडर्ड प्रोसीजर्स को अडॉप्ट कर करके हम इसकी एक्यूरेसी को इंश्योर किया जा सकता है. हेलो.
Thank you, sir, for such a lovely presentation. Now, next participant, Asta ma'am, please be ready with your PPT and you can unmute yourself also.
Okay, thank you so much, sir.
Ma'am, you want us to present your PPT or you'll share your screen?
Ma'am, I'm sharing my screen. If it's not visible, then please share it.
Sure, ma'am.
I'm just trying.
Yes, ma'am, please, ma'am. And also, ma'am, our session chair is asking you to put your... Thank you, ma'am. I'm pinning you.
Thank you, sir.
Yes, now you can share your screen, ma'am, if possible.
Yes, sir. Sir,
yes, ma'am, screen is visible. Yes, ma'am.
Okay. Good afternoon, everyone who is to all the dignitaries present over here. Sir, my research paper is about the critical analysis of digital forensics. Digital forensics, digital forensic, the research paper dealt with under 2 categories. First is about the digital forensics and its objective, and secondly it deals with the legal challenges which are faced by the digital forensic in legal perspective with respect to India, the country like India. So before proceeding further, I would like to take you towards understanding the definition of digital forensics. So as per digital forensic, it is just extension of branch of forensic science that deals with looking into data, information and material that is obtained from various digital devices. So digital forensics, when we talk about digital forensics, it is classified under 4 categories. First is computer forensics, network forensics, mobile forensics. These are some of the forms of digital forensics. It is just like a shoe for a spike like cybercrimes. It is the branch of forensic science that deals for the offenses committed under cyberspace. So when we talk about digital forensic, when we go through it, its history relates to Hans Gross, who in 1840 decided that science need to be activated in the law area. So when he decided it, later on US formed the laboratory, forensic laboratory in 1942, and FBI started working on it. Later on, Simpson Granville-Finkel is one of the person who decided that digital forensics need to be introduced so that we are entering in the step of digital era. This digital forensics need to be clearly introduced in law so that the offenses like cybercrimes and and other related offenses need to be clearly investigated. With respect to India, some provisions, major provisions related to digital forensics are 79A of IT Act 2008, 65B of Evidence Act, which deals with the admissibility of electronic evidences, Section 3 of IT Act, which defines according to the uh, authentication of electronic records, and 65B deals the admissibility. Digital evidences, when we talk about digital evidences, it includes computer evidence, digital audio, digital video, cell phones, digital fax machines, etc. The major problem in India with regard to digital evidence is that there is no formal guidelines regarding digital evidences. Every digital forensic, there is provisions for admissibility of digital evidences, but there is no proper guidelines. So if the evidences which is collected, through the evidences which is collected through the evidences which is collected in the investigation and are not proper, then the evidences is inadmissible in the court. So they are not clearly visible. The major objective of the computer forensics are it helps to recover, analyze, and preserve computer and related material in such way that it helps the investigation agency to present them as evidence in a court of law. It helps to postulate the motive behind the crime and identity of main culprit, and it produces computer forensic report which offers a complete report on investigation process, and it preserves the evidence by following the chain of custody. These are major objectives. When we go through the process of digital forensics, it goes through 5 processes, that is identification, preservation, analysis, documentation, and presentation. Identification is to identify the resources through which such offense is generated. Then the forensic analyst preserves such evidences. Then he analyzed on the basis of such facts which he preserved. Proper documentation is created, and thus such documentation is then presented to the court. The major challenges which are faced with respect to legal perspective is major issue. One is the major issue of privacy. The concept of privacy is the precise reason cybercrimes have entered the aforementioned sphere. When the foreign investigators are making every efforts to strike a balance between gathering evidence and avoiding violating users' privacy. This area still has a way to go in regards to dealing with the issue of protecting people's personal information. So when with regard to privacy, when we talk about the when the investigator investigates the offense, the major problem with digital forensic is that they have to go through various processes. So when a computer is investigated by the analyst, it is not necessary that such uh, he could directly search the thing which he is investigating. He have to move through various processes through of digital beings. So that is the reason the privacy became the major reason. One of the cases A. Shankar versus state representative of DSP. Second is the limited power to investigators. That is the power collect basically the power of the investigators are given through the warrant under CRPC. So warrant is limited to a particular area which is used for the collection of evidences. It cannot be work under the common umbrella. So if the search warrant is issued for a particular purpose, then the investigator, and if the investigator have the more chances to get evidences from other sites, so he have to take the another warrant for issuing in such processes. So it does become the investigators have very limited powers. It could also be seen under jurisdictional issues. If the offense is committed outside India, then and the computer is located in India, then also there would be a jurisdictional issue in cases of powers of investigators. The other issue is with the admissibility of evidences. When we talk about section 59 of documentary evidence, which consists of contents of documents, 65A and 65B includes with the admissibility of electronic evidences. 65B deals with the procedure for production of digital evidences in court. However, there is no section or guideline is provided for the collection of evidences. Evidences collected through improper procedures is not admissible in the court. When we talk about 65B, it became in Arjun Pandit Rao Porkar, it becomes a prerequisite condition to give the certificate under section 65B. Next is issue regarding safeguarding of digital evidences. We are the country like India where the cases are very longevity of there are cases. Sometimes it cases takes almost 30 years to resolve. So when we take about safeguarding the such evidences for such a long period, it became very complicated and there are more chances of deteriorating such uh, Next is the investigation of working computer. The collection of evidences through electronics is a tedious task, so offender may anytime hack the electronic or may send the virus to the system for the destruction of evidences. Thus, destruction of evidence is could be a very easy task in case of working computers. There is always a issue regarding the tampering of data. Gathering digital proof is simpler, but its security and protection from hacking, data breaches, and other threats is challenging. There are certain more operational issues are well, like issues regarding the amount of data which is collected through various offenses for various cyber offenses, like the data is collected through camera or CCTV cameras or through various home security cameras. So such data need to be collected, and to analyze such data is a tedious task. The data collected through these tasks would be could be hacked by anyone or could lead to the could not lead to the proper evidence and the trial of the court. Issues there are regarding excess of management in issues with regard to human error. Human error in respect to the evidences, if they are not well handled, then it may lead to incorrect informations and it may give the investigator lost path towards it. And the transmission of data became vulnerable because data might be compromised, revealed, or altered. Digital evidences transportation requires very careful protection. Password protection alone is insufficient when storing on conventional device because they can be easily stolen and compromised. Another one is acquisitions and at last the conclusion. So there is the major problem is with digital forensic is to obtain, preserve, inspect, analyze and present digital evidence in the dynamic electronic environment. And it is very necessary to make or give the directions for the digital forensics to apply it ethically and lawfully, and to make the proper guidelines for the digital forensics to make the collection of evidences successful. Thank you so much.
Thank you, ma'am. I'm audible?
Yes, sir, you are audible.
I'll ask the audience if there are some questions.
Okay, sir.
Good afternoon, ma'am. Can you hear me?
Yes, sir, I can hear you.
Well, it was a great topic and you have presented well.
Thank you so much, sir.
I have one question. Ma'am, when it comes to legal practitioners, it is always said, like I'm talking about advocates, it is always said that the more the age of an advocate, the more value he holds. Correct?
Yes,
so,
sir.
If we look into Indian scenario, there are majority of the advocates are of good age. They have great experience. But when it comes to digital mode or digital evidences or digital forensics, they have no legal knowledge as such. So how to address this problem and what are your views on it?
Sir, with advent of technology, I think the advocates need to be more active and they have to understand more about digital forensics. And new advocates that are generating, they also need to understand the digital forensics, which is not prevalent much among in Indian courts. So there has a problem, but they have to understand the topic, and to make it more clear, they have to understand the basic forensics about digital forensics. Experts and experts more need to take workshops like kind about this topic. And I think proper formulations need to be made by the legislative assembly.
So I have a follow-up question. Ma'am, I have a follow-up question. Like you said,
Yes, sir.
various workshop has to be organized, and then who is responsible for it? Who is going to organize these? Who is going to bear the cost? And how overall it impact upon the significance of digital forensics? Do you think that this tedious task will somewhere put another challenge in front of judiciary?
No, sir. I think the forensic departments which are dealing with science, they have already experts who are dealing with digital forensics and scientific basically forensic in criminal investigation. But in case of digital forensics, legal area is need to be more active towards such thing. They have to understand that the basic resources, the privacy issue, the concern regarding the technologies. So such addresses need to be more active in colleges, in law colleges especially, where they need to understand that what is the major problem. The persons, for example, the persons who are not taking the cyber diploma or cyber expertise in law, so they don't even understand the basic in digital forensics and the other major problems. So for proceeding towards advocates who are taking the task like of digital forensics, so they need to understand the basic concept of these, and to maintain the proper privacy and such issues.
अरे ऐसे अनाउंस कर दो भाई रिकॉर्ड हो रहा है नहीं हो रहा
We are over for the day, and our second technical session will begin from tomorrow at 10:30 p.m. Thank you so much. ऑनलाइन लिंक सेम रहेगी.